So could you explain exactly what this ruling means?
Yeah, so this case challenged the admissions programs at Harvard University, which is the oldest university in America, and then University of North Carolina, which is one of the oldest public universities in North America. And both of those admissions process used race at different points in the multi-step process. And what the factual findings were, as credited by the Supreme Court, was that in many instances, race was a determinative factor in who was admitted and then who was not admitted. And the Supreme Court said that that use of race by Harvard and by UNC, which many universities use race in similar fashions, violated the 14th Amendment's Equal Protection Clause.
Could you give us a brief history and evolution of affirmative action?
Sure. Affirmative action was first used as a term and then probably as an activity in the Kennedy administration. The Kennedy administration identified affirmative action as a way to give racial and ethnic minorities not necessarily an advantage, but to make sure that they were included in the hiring processes of the federal government. And then affirmative action beginning in the 1970s proliferated beyond government hiring to all different aspects of American society. The first major case was a 1978 case called Bakke versus University of California, Davis Medical School, where the Supreme Court, in a fractured opinion, upheld the idea of affirmative action, but in that particular case struck down the University of California, Davis's use of it because the use was a quota or a set aside. And then that's where the law stood up until 2003, so about 25 years later, when the Supreme Court, in a case called Grutter versus Bollinger, upheld the University of Michigan Law School's use of affirmative action as, quote, one factor among many in the determination of admissions to the law school.
So how will the lack of race consideration impact future enrollment in colleges and universities?
Yeah, that's a great question. And I think it depends on a lot of variables. So one variable is what happens if schools stop using race, period, in their admissions policies, which is what the court suggests that schools should do, at least as a direct matter. And you can look at states like California and Michigan, both of which passed state constitutional amendments that prohibited the use of race in admissions. And just to be fully open, there's debates about what the impact of those amendments were. My reading of the evidence is that those state school systems overall had increases in racial and ethnic diversity, but that there was a kind of stratification of the racial and ethnic diversity. So, for example, at the highest level of the University of California system, there's actually in some schools a majority of Asian Americans, whereas Hispanic Americans and African Americans tended to have higher proportions, but at schools in different points in the ranking. I think another variable will be, to what degree will the schools indirectly try to utilize race to achieve the same criteria, the same goals that they had previously been using? And I think there's good evidence to think that universities will do that. Universities arguably have been, and that's actually the court's perspective, have been working very fast and loose with the constraints that the Supreme Court had put down in Grutter versus Bollinger. So it wouldn't be surprising that they would continue to try and use means indirectly to achieve their same goals of racial and ethnic diversity they've previously been using.
Are there instances where race could still be considered?
Yeah, so the court, and you saw this actually in the oral argument as well, there was a lot of debate over if a university could not use race in its express criteria to admit or not admit students, are there other ways in which race is relevant to university admissions policies? And the majority opinion written by Chief Justice Roberts for 6 justices acknowledged that, for example, if a student has experiences as a racial or ethnic minority that have helped form that student to be a better man or woman, and therefore a better student in school, maybe a better citizen in the future in the United States, that would be a relevant consideration for the university that the university could take into account. So there are ways in which the Supreme Court majority expressly acknowledged the use of race, but only in an indirect way. You could also imagine a state university, let's say like Ohio State, where I'm currently at Ohio, using other proxies that have correlations to race, but in fact themselves are not race, like, for example, zip codes, making sure that Ohio State has a certain number of students from every zip code in the state of Ohio would be another way to try and maintain a level of racial and ethnic diversity that reflects Ohio generally without using race itself. So I think there are a lot of tools and mechanisms that universities can and likely will use.
All right, thank you so much for joining us, Professor Strang.
My pleasure.